Let's talk about one of the most maddening things you can face in any legal battle. The other side just won't cooperate. It's infuriating. Well, in this explainer, we're going to break down a clear, actionable playbook for exactly how to handle it when they try to stonewall you. You know the feeling, right? It feels like it's designed to make you panic. They're ignoring your emails, blowing past deadlines, and just generally creating chaos, and it can make you feel completely powerless. So, what can you actually do when you're up against a wall of silence? First things first, let's put a name to the problem. It's called stonewalling. And it's so important to understand this isn't just about them being slow or forgetful. No, it's a deliberate pattern of behavior. It's a tactic used to gain an unfair advantage by messing up your case prep and pushing you into a constant state of crisis.
I bet some of these are going to look very familiar. You've got the selective replies, where they only answer the one unimportant question you asked. Or the document drip, sending just enough to make it look like they're doing something. And oh, a classic, the massive document dump right before a hearing, designed to be a total ambush.
Okay, so you know their moves, but how do you counter them? Well, it all starts with a brand new game plan. And this isn't about learning a few new tricks. This is about adopting a completely different mindset.
Your gut reaction is probably to get angry, right? To get louder, to fight fire with fire. But listen, that is a trap. That's exactly what they want. So how do you really fight back against all this chaos? Here it is, the big shift in your thinking. You don't fight, you refuse to get sucked into their drama. Instead, you build.
This right here, this should be your new mantra. Write it down. Your goal isn't to win some shouting match with the other side. Your goal is to build a clean, clear, undeniable record that makes it incredibly easy for a super busy judge to look at the facts and rule in your favor. Fast.
So when they bring the chaos, you bring the calm. Your superpower is being structured when they're a mess, being consistent when they're all over the place, and documenting everything. You become the reasonable, organized adult in the room, and believe me, that gives you all the credibility.
Okay, that all sounds great in theory, but how do you actually do it? This next part is all about the practical tools you need. It's time to build your credibility machine. And you're going to love how simple this is. Your machine really only has two main parts. First, a dead simple folder structure to keep every single document organized, and second, a master log that tracks every single interaction. Now, this master log, this is the engine of your entire credibility machine. Just look at these columns. This simple spreadsheet turns all your frustration into rock-solid evidence. Every ignored call, every missed deadline, every vague promise, it gets its own line item. It stops you from getting hijacked by emotion and gives you instant, motion-ready facts. All right, your machine is built, your folders are ready, your log is open. So now, how do we actually talk to the other side? This is critical. From now on, you're going to write every single message as if it's going to be Exhibit A in a future court filing. And the difference is just night and day. On the left, that's the email we've all written at some point, right? The long, emotional one, full of blame that feels good to send for about 5 minutes and gets you absolutely nowhere. But on the right, that's the email that wins. It's short, it's procedural, it's all facts and deadlines, and it clearly says what happens next. And here is a perfect example of this in action. Discovery, by the way, is just the formal process of exchanging required info. And a motion to compel is simply the official way you ask a judge to make the other side do what they're supposed to do. See how this email isn't emotional at all? It's just a professional statement of fact. It gives a hard deadline and clearly states the consequence. It's perfect. And by being this clear, you get to set this beautiful little trap. You force them to a choice. They can either finally cooperate, or they have to go on the record in writing explaining why they're refusing. They can't hide in that gray area of delays and vague promises anymore. This one sentence is a total game changer. But what if they just ignore even your perfectly crafted, exhibit-ready email? You don't get mad, you don't panic, you just calmly take the next logical step on what we call the escalation ladder. It's a clear, predictable path that judges completely understand and respect. This timeline lays it all out. Day 1, you send that clean request. About a week later, you send your professional follow-up. A few days after that, a formal deficiency letter. And if you still get nothing, then you file your motion to compel and you attach every single one of your calm, professional attempts as exhibits. You've built an open and shut case, step by step. And that motion isn't some 50-page novel about how terrible they are. Nope, it's a simple, clean map for the judge. A short background, a clear timeline, a list of what you asked for, what they did, and exactly what you want the judge to do about it. That's it. You're making it almost impossible for them to say no.
All of this work, every log entry, every carefully worded email, it has all been leading to this one final phase, winning with the judge. This is where your structured, professional approach really pays off.
First, we've got to redefine what winning actually means. Forget the courtroom dramas on TV. A real win isn't some fiery showdown. A real win is a simple, boring, but incredibly effective piece of paper signed by the judge that orders the other side to cooperate. That's the victory.
And how do you get that beautiful, boring order? With a fantastic tool called the one-page trinity. This is what you bring with you to your hearing. A one-page timeline, a one-page list of what's missing, and a one-page proposed order for the judge to sign. You're not just showing up with a problem. You're handing them the solution.
And when it's your turn to speak, you don't have to give some long, dramatic speech. This script is basically all you need. Notice how it's calm, procedural, and totally fact-based. You're just reporting the results of the professional process that you followed perfectly.
You see, this whole playbook really boils down to one huge shift. You completely refuse to engage in their emotional conflict, and instead, you pivot to procedural precision. They create the problem. Your organization, your documentation, and your clarity make you the obvious solution for the court. So we've covered the mindset, the system, and the step-by-step process to turn all of that chaos into clarity. The playbook is now yours. So the only question left is, what's the very first step you're going to take to start building your case and bring some order back into the chaos?